Marbury versus Madison established that the court had real power and that it would exercise that power. It had power over the executive branch and it had power over the legislative branch. So in 1803, the case comes before the Supreme Court. The question in the case is, what happened to Marbury's commission? Why didn't it get delivered? There's a trial in the Supreme Court. We don't see trials in the Supreme Court very often. We certainly haven't seen them in our lifetimes. But there's a trial at the Supreme Court. And the question of the trial is, what happened to Marbury's commission? Why didn't it get delivered? Who's presiding over the trial? Chief Justice John Marshall. Who knows the answer to that question? Chief Justice John Marshall. But he is not going to opine about that because now he's the Chief Justice of the United States. So they have this trial. The other thing that happens in this trial, and Marshall mentions this in the opinion where he calls it the peculiar delicacy, the Jefferson administration does not show up to defend themselves. That's how little power the court has, right? Thomas Jefferson does not send James Madison, Marbury versus Madison, his Secretary of State, to even defend what they've done. They don't actually care what the Supreme Court says. They don't think the Supreme Court can do anything to them at all. So they don't show up. So you have this crazy trial in which the defendants don't come because they don't believe that the court has any power. The person who knows the answer is presiding over the trial. Okay, so all of this happens. At the end of the day, John Marshall writes the opinion of the court. The first question in the case is whether John Marbury is entitled to his commission, whether he has a legal right. Was there a legal right vested in him that he should be entitled to becoming a justice of the peace, or was it the case that it was purely discretionary? If the president nominates him and another president can take it away, then it doesn't really matter. There's no case. He doesn't have a legal right, and then he won't have a legal remedy. But what Chief Justice Marshall says is the statute says once you're appointed, you get to stay there for 5 years. And the appointment is complete, in Marshall's view, when the commission has been signed and sealed. Nothing about delivery. That's what he thought when he was Secretary of State, so he didn't think it was important to deliver this. And that means the new president can't just take it away. He has this right for 5 years. The reason that question is important is because John Marshall, as Chief Justice of the Supreme Court, is saying there are two kinds of decisions that get made by the president. Some kinds of decisions that get made by the president are his alone. He has discretion. He gets to decide what he wants to do. If he decided John Marbury wasn't the guy he wanted to be Justice of the Peace, John Marbury would not have a right to that commission, right? If he wanted some other political crony or some other guy to become Justice of the Peace, Marbury has no right. But there are some things that the executive does by law and is required to do by law. And when the executive acts by law, ministerial duties, administrative duties, following the law, then the court can review that executive action, right? So in answering this question, does John Marbury have a legal right to his commission of justice of peace? It doesn't sound like such a big question. It's a huge question. It enables John Marshall to assert the judiciary gets to review some kinds of decisions made by the president. Not all kinds. There are political questions the president gets to decide himself or herself, but some questions are legal questions that the court gets to decide. The second question is a technical question about whether the remedy that Marbury is asking for, which is called the writ of mandamus, is the right remedy. Marshall says it is the right remedy, and then you move on. Now here comes the big question in the case. The Judiciary Act of 1789 says that cases like Marbury's can be heard as an initial matter in the Supreme Court. That's how you get this trial at the Supreme Court. The Supreme Court has original jurisdiction. In Article 3 of the Constitution, cases like Marbury's are not listed as cases in which the Supreme Court has original jurisdiction. Article 3 lists a certain category of cases in which the Supreme Court has original jurisdiction. Then it lists a certain category of cases where the Supreme Court has appellate jurisdiction. Those seem like Marbury's kind of case. Then it says Congress can make exceptions. If Congress changes, then Congress can change it. So what Marbury says is there a conflict between the Constitution and the statute? And Marbury says if there's a conflict, the Constitution wins. And the court gets to say if there's a conflict or not. This is judicial review. Now, if you were to read closely the statute and the Constitution, you might not think there was a conflict. There are ways to interpret the statute and the Constitution that can make them consonant and that can say that they're not in conflict. But what happens if Marshall says this statute is constitutional? If Marshall says this statute is constitutional, then he has to order Secretary of State James Madison and President Thomas Jefferson, he has to order them to give John Marbury his commission for Justice of the Peace. Does he think that they're going to do that? No, they didn't even show up for the trial, right? They're not going to do that. So he wants to avoid that at all costs. So what does he do instead? What he does instead is absolutely brilliant. He says this statute is unconstitutional. And in saying that the statute is unconstitutional, he establishes judicial review over federal legislation. That's a huge deal. That aggrandizes the power of the court in a tremendous way. By also finding that the statute is not constitutional, he doesn't test that power. The statute is unconstitutional. Marbury is not entitled to his commission, and John Marshall does not have to order anyone to do anything. So in one fell swoop, in this one case from 1803, John Marshall establishes that the federal judiciary can review acts of the executive, the federal judiciary can review and strike down acts of the Congress and the federal legislature, and he does it all without ever requiring anyone to do anything because he struck down this law, and so thereby not testing power that he knows he pretty much does not yet have. But he asserts the power, and then that power is going to sit there in Marbury versus Madison, waiting for a day when he has aggrandized the power of the court enough that he'll actually be able to strike down a law and make it mean something and make people do what he says.